This is the detective investigative file.
And are these, sorry, go ahead, please review.
For RD number HX475653 and HX486155.
And are these records kept in the ordinary course of police business at the detective division?
Yes.
Okay. Do they appear to be true net copies of the files in the detective investigative file in this case?
Yes.
Okay. And sir, take a look now, if you will, at Exhibit 1B. Thanks. Could you please tell us what Exhibit 1B is?
This is the permanent retention file for RD number 475653.
And is this permanent retention file the file that you were requested by Sergeant Gallagher to permanently retain in those two separate RD numbers?
Yes.
Okay. And are these records kept in the ordinary course of the Chicago Police Records Division business?
Yes.
And do these records in front of you, labeled 1B, appear to be true and accurate copies of the permanent retention file in this case?
Yes.
Thank you. At this time, I'd like to proceed by way of stipulation.
Okay.
It's stipulated between the state and the defense, at least regarding David March, that the foundation for Exhibit 1A and 1B has been laid, and both exhibits are admitted. So stipulated?
So stipulated, Your Honor.
All right, so that stipulation is received and admitted.
I don't have any further questions. Mr. Perfetti, thank you.
Okay. Mr. Pugh or Mr. Breen?
Good afternoon, Mr. Wright.
Good afternoon.
Can I ask you a couple of questions about some items that are already in evidence? The first question is, do you see in front of you Walsh OBR number 1?
Yes.
And this is what's been referred to as an officer's battery report, is that correct?
Correct.
And does this form have any instructions for the officer filling it out?
Yeah, at the top.
And is a form required to be filled out when a sworn member is the victim of a murder, aggravated battery, aggravated assault, or an assault while performing their official duties or off duty?
Yes.
And in terms of this exhibit, Walsh OBR 1, do you know when this form was submitted?
Should be on page 2, right?
I think it's tab 14.
Tab 14. I don't see the date submitted.
Beg your pardon?
I don't see the date submitted.
Okay, so it would be fair to say that in reviewing Walsh OBR number 1, there's nothing on this document to allow you to provide any information as to when this document was submitted.
No, not on this document.
And indeed, the document before you, Walsh OBR 1, it appears to be an official police document that's been populated with some information. Is that right?
Yes.
Are you familiar with the procedure that police officers use to populate these types of forms?
Vaguely.
Well,
Yeah.
and I'm asking if you know.
No, it's a computer application that they populate, but I don't know exactly how they go about doing it.
About the computer application, is that right?
No, as far as filling it out, no.
And perhaps most importantly, you don't know what the computer screen that the individual officer inputs information on, what the questions are, or any of those procedures at all. Is that right?
No, I don't.
And you certainly wouldn't have any knowledge as to whether or not this form, as it exists in your book that you're looking at, was ever seen by Officer Walsh. Isn't that correct? The printed form.
No, I wouldn't.
The procedure is the officer actually inputs the data onto a computer terminal, and then it gets sent and it ends up in the records department at some point. Is that correct?
The officer battery reports don't even end up in the records division.
They don't.
No.
So this is not this document that you've identified, Walsh OBR, this is not something that would be in your department?
No. Typically, unless it was done on paper and then it was forwarded to us, if the computer system were to be down or whatever reason may be.
So would it be fair to say that Walsh OBR number 1 was never forwarded to your department?
Correct, not to records.
Okay. Can I ask you then regarding, please, if you could turn then to Walsh TRR 1, which is in your book. I believe you'll find it under tab 11. If we could get that published, please. Are you looking at tab number 11, that which has already been admitted into evidence, which is Walsh TR number 1?
Yes.
And would your answer be the same as to Walsh TR number 1, is that this is also a document that wouldn't have been forwarded to your department for attention?
Correct.
And again, you don't have any knowledge as to how this form was actually created, do you?
No.
If I could have just a moment.
Take your time.
So, if I could, Mr. Corvetti, when you were testifying on direct examination, Mr. Watson was asking some questions about these documents. You identified them as being submitted by Officer Walsh. You were just reading off the document, isn't that right?
Correct.
You don't have any personal knowledge that Mr. Walsh actually submitted these documents. Is that fair to say?
No. I mean, I was reading off whatever documents were here.
What's that?
I was reading the documents that were presented.
Thank you very much. Because you had nothing further.
Okay, Mr. Fahey?
Judge, if I could adopt the cross-examination of my co-counsels.
Okay, so you're going to adopt the cross-examination of Mr. McKay and Mr. Pugh?
Yes, Judge.
And I would like to adopt the cross-examination of Mr. Pugh.
Okay, one second. Okay. Mr. McKay, you're adopting Mr. Pugh's cross-examination. Okay.
Your Honor, if you feel it necessary, I'll adopt Mr. McKay and Mr. Fahey's adoption of other stuff.
Very technical, Mr. Pugh. So, all right, so Mr. Walsh then is going to adopt the cross-examination of Mr. McKay. And if Mr. Fahey does any additional cross, you would adopt that as well?
I would.
Mr. Fahey, other than adopting their cross-examinations, do you have any additional questions?
Judge, I do just. Mr. Perfetti, if I understand your testimony, the officer battery reports that you testified on about on direct examination, those are not reports that ever make it to the records division?
No, they're automated reports, so.
So your testimony applies to all of the officer battery reports that you testified about in direct examination, correct?
Yes.
And the same with the tactical response reports. Those never even make it to the records division either.
No, they don't.
Is the officer battery report that's prepared, is that for statistical purposes?
I don't know.
Do you even know what the purpose of it is?
No.
And if I may approach, I'll do it the old-fashioned way, Judge. I think it's marked as GAPNY OBR1. It's your tab 15. Is that the officer battery report that you testified about direct examination? If you can turn to tab number 15. Do you have it in front of you?
Yeah, I got 15 up.
That officer battery report, the officer's name that is typed on that report is Thomas Gaffney, correct?
Correct.
But in looking at that exhibit, can you tell when that was submitted?
No.
Judge, I have a question.
Okay. State, any redirect?
Thank you, Your Honor. May I approach the witness?
You may.
Mr. Perfetti, I'm handing you what defense counsel gave you as the detective investigative file, Exhibit 1A.
Okay.
Do you see that?
Yes.
On page 303 of the numbered detective investigative file, what is that?
Officer's battery report, HX 475653.
And that's kept in the detective investigative file.
Yes.
On page 305 of the detective investigative file, what is that?
That's the tactical response report.
And that's kept in the detective investigative file.
Yes, a copy became maintained in the area file.
On page 307.
State, who is it the TRR for and who was the OBR for? Just so the record's clear.
Mr. Perfetti, on page 303 of the detective investigative file, which is marked as Defense Exhibit 1A, is that the officer's battery report for Jason Van Dyke?
Yes.
On page 305 of the detective investigative file, marked as Defense Exhibit 1A, is that the tactical response report for Jason Van Dyke?
Yes.
On page 307 of the detective investigative file, marked as Defense Exhibit 1A, is that the officer battery report for Joseph Walsh?
Yes.
On page 309 of the tactical response report, is that the on page 309 of the detective investigative file, marked Defense Exhibit 1A, is that the tactical response report for Joseph Walsh?
Yes.
On page 311 of the detective investigative file, marked Exhibit Defense 1A, is that the officer battery report for Thomas Gaffney?
Yes.
On page 313 of the detective investigative file, marked as Defense Exhibit 1A, is that the tactical response report for Thomas Gaffney?
Yes.
Who keeps the detective investigative file?
The respective area.
And who of the assigned detectives keeps the detective investigative file?
Typically the assigned detective.
And in this case, the assigned detective was Defendant March.
Yes.
Defense counsel did not identify for you a single report in the permanent retention file or the detective investigative file where Defendant March corrected any false information, did they?
No.
Defense counsel did not identify for you a single report in the detective investigative file or the permanent retention file where Defendant Walsh corrected any false information.
Objection, Judge, assumes the fact not in evidence that my client has access to any of these files.
That's sustained. You can rephrase though.
Is there a single report that you've identified in the permanent retention file or the detective investigative files where Defendant Walsh corrected any of that false information?
No.
Objection.
That's sustained.
Does a police officer in the Chicago Police Department have access to their own reports?
Yes.
Objection, foundation.
That's overruled. I think that's what he's doing now.
Yes.
Does a police officer in the Chicago Police Department have the ability to request access to the permanent retention file for review?
Yes.
Does a police officer have the ability to request access for review of a detective investigative file at the Chicago Police Department?
I don't know what the Bureau of Texas policy is on that.
Is there a single report in the detective investigative file or the permanent retention file where Defendant Walsh corrected his TR?
I'm going to object. And the objection is as follows. There's been no evidence presented that there was a requirement or a duty or a necessity for Patrolman Walsh to correct anything that's been submitted in this case. So it assumes a fact not in evidence.
Mr. Watson.
We went over the Rule 401, which requires a police officer to promptly report to the police department any information involving a crime or other unlawful act. The crux of this case is submitting false information. The failure to correct that is a violation of Rule 41 of the Chicago Police Department.
Okay. Anything further, Mr. Pugh?
Nothing other than foundationally, the state would be required to prove that Mr. Walsh, Officer Walsh, would put on notice that there was anything incorrect or false about any report that he supposedly submitted in this case.
At this point, it is assuming a fact not in evidence, so the objection is sustained.
Does a Chicago police officer have access to their own tactical response report?
Objection asked to me.
That's overruled.
Thank you, Your Honor.
Yes.
Does a Chicago police officer have access to their own officer's battery report?
Yes.
Does a Chicago police officer have access to their own case incident report?
Yes.
Does a Chicago police officer have access to their own case supplementary report?
Their own case supplementary report? Yes.
Is there a single place in the detective investigative file or the permanent retention file where any of the tactical response reports or officer battery reports are corrected?
Objection.
That's overruled. You can answer that question.
I'm not aware of any, no.
Nothing further here.
Okay. Any recross, Mr. McKay?
No, Your Honor.
Any recross, Mr. Pugh?
Yeah, yes.
Okay, give me a second to get to the right spot in my notes. All right, you may proceed.
Thank you. Mr. Perfetti, just to clarify a couple of things. As to the TRRs and the OBRs, your department does not keep those, correct?
Correct.
Do you know where those are retained?
Well, they're computer generated, so to be retained within our clear application, and our hard copies.
You mentioned an application.
They are automated reports, so they're kept within the clear application.
Are you the keeper of the clear application?
No, that would be the Information Services Division.
Okay, so in concerning whether or not an officer has access to go back and correct these things, you're basing that on knowledge of your own department or your knowledge of somebody else's department?
Somebody else. I never said they had the access to go in and change anything.
I thought, and I'm sorry, I thought that when Mr. Watson was asking questions, he had asked whether or not an officer has access to go in and change a report that's already been submitted.
No, I didn't take that.
So officers can't do that, correct?
No, they cannot change their reports.
Very good. Thank you very much.
Okay, any recross, Mr. Fahey?
Judge, if I could just adopt the recross of
As would I,
Mr. Pugh.
Okay, you can adopt. Any redirect, Mr. Watson?
Mr. Perfetti, when records are forwarded to the Record Services Division and kept in the permanent retention file, an officer cannot change their report, can they?
No, original reports cannot be changed.
Can an officer provide a report to the Record Services Division that reports or corrects the false information in existing reports?
An objection to false information.
That is sustained. Rephrase.
Can an officer provide notification concerning a tactical response report that they have submitted to the Record Services Division?
I don't know the answer to that.
They can't change their existing report, though.
You cannot change your original report now.
An officer at the Chicago Police Department can create a report or notification about a prior report that they have submitted.
Yes.
And they can forward that report or notification to the Record Service Division.
Yes, it would go through channels, but yes.
Nothing further, Your Honor.
Okay. Any re-cross? Mr. McKay?
No.
Mr. Pugh?
No, Your Honor.
Mr. Fahey?
No, thank you, Judge.
All right, thank you. You're excused. You may step down. State,
you.
call your next witness.
State calls Investigator Earl Brigs.
Judge, can I
Yes?
approach, Your Honor, outside the presence of the witness?
Yes, I'm going to ask the witness to step out into the hall. Mr. McKay?
Yes, Your Honor, I'm making a motion to bar Mr. Briggs from testifying in that, based on the discovery, I anticipate what I think he's going to say. The problem is that Mr. David March is not charged with this alleged misconduct. Mr. Briggs is an investigator for the Cook County Medical Examiner's Office. And based on the indictment I have before me regarding all three counts, there is no allegation that David March is conspiring or committing official misconduct or committing obstruction of justice because of an alleged statement the state believes he made to this individual. So it's not relevant based on the charges. Secondly, if the state wants to compare this alleged statement to this individual from the ME's office, similar to that of like proof of other bad acts, proof of other crimes, so to speak, they didn't provide us in writing with their intention to do that. So for those two reasons, Your Honor, I'm asking that Mr. Briggs be barred from testifying.
Thank you. State?
The state identified it in the voluntary proffer of the bill of particulars that the defendants requested. This particular testimony is identified as a statement against defendant March in that bill of particulars, and the testimony and statement of defendant March to Earl Brigs is identified as an act in furtherance of the conspiracy in the voluntary proffer.
I'll grant.
Mr. McKay, you can respond to the court.
Oh, I'm sorry. Well, I'll grant Mr. Watson is correct that it was volunteered during the proffer, but it's not charged. And that's my basis in that it's not relevant based on the indictment. It's not charged.
It's hard for me to rule when I don't know what the alleged statement is.
The statement is identified in the state's response to the defendant's motion for bill of particulars and the state's voluntary bill response to the bill of particulars.
Judge, I can cut to the chase.
The statement at issue and Mr. Briggs' anticipated testimony is that on October 20th, 2014, defendant March called the ME investigator's office. Defendant March spoke with Investigator Earl Brigs. And defendant March told Investigator Earl Brigs that, quote, the subject fled the scene on foot, where at 4112 South Pulaski, the subject was stopped by officers assigned to beat number 845R. And here's the crux of the issue, Your Honor. The officers announced their office as Chicago police officers and ordered the subject to drop the knife. The subject lunged at the officers with the knife.
Is that in your response in opposition to defendant's motion for a bill of particulars that was filed December 18th
Yes,
of 2017? What page were you reading from? I'm just trying to get to the...
May I, Your Honor?
Yes, sir. Thank you.
Top of page 19, Your Honor.
Thank you. Anything further, Mr. McKay?
Yes, Your Honor. Again, even though counsel wants to include that in a proffer on alleged co-conspirator statements, he's not charged with making a false statement to a medical examiner's case, a medical examiner's investigator. He is not charged with it. And if they want to put in uncharged conduct, then it has to be in writing, separate and apart from any co-conspirator proffer. There is a procedure under Illinois law regarding the prosecution's attempt introduction into their case in chief regarding uncharged conduct.
Your Honor, what I...
Let him finish, and then I'll give you an opportunity to respond.
Thank you, Your Honor.
I'm done, Judge. It's not relevant to the charges pending against this man.
Okay. Mr. Watson.
What I identified for the court is not the co-conspirator proffer. What I identified for the court is a response to a bill of particulars.
Now, I understand you're saying that they were on notice that you planned on using or eliciting this testimony. I understand exactly what you're saying.
Defendants are charged with furnishing false information. That is false information. Defendants are charged with official misconduct by failing to perform mandatory duty required under law. That statement is official misconduct. The defendants are charged with performing an act that they are prohibited under law, under official misconduct. That is an act prohibited under law.
I've had an opportunity to look at the bill of particulars. I've had an opportunity to review the indictment. Mr. McKay, it is charged in the indictment. I'm sure it's in here more than just once, but specifically paragraph 4, it indicates that it was part of the conspiracy that David March, Joseph Walsh, Thomas Gaffney, and individual A were members of the Chicago Police Department who were involved in the investigation of the fatal shooting of Laquan McDonald. And then I'm just going to summarize down a little bit. Later in that paragraph, it says that they coordinated their activities in order to protect each other and other members of the Chicago Police Department by furnishing false information, making false reports, failing to report or correct false information, and then it has other allegations as well. So it is in the charging document. You are on notice. It was in their bill of particulars. Should a motion have been filed for proof of other crimes? Probably. But on the other hand, the defense was on notice, and you could have always filed a motion in limine. Prior to today, you've been on notice that this witness was going to be called for quite some time. You could have filed a motion in limine. But even if you did, your motion is, even though it's an oral motion in limine today and not in writing, your motion is denied.
Thank you.
You're welcome. So you can call the witness.
Judge, prior to the witness testifying on behalf of Mr. Walsh.
Are you adopting all of that?
No, because I don't think that witness applies to our client.
Okay.
At least at this point in time, he's going to be testifying to, we believe, statements where the declarant's co-defendant And of course, based on our previous objections, we're making that objection now, absent foundation being laid, it shall only be considered against the declarant.
Okay.
Judge, on behalf of Thomas Gaffney, we would also make that objection.
Okay. Your objections are noted, but they're overruled at this time. You can call your witness.
You're going to step up. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes. Good afternoon, Your Honor.
You may proceed.
Your Honor, the state has prepared a witness finder for Mr. Briggs with 2 exhibits. Those are the same exhibits that have been provided to the court, and to all defense counsel may approach Mr. Briggs and provide him a copy of the 2 exhibits.
Any objection, Mr. McKay?
No.
Miss-
Can I see this?
Mr. Pugh?
No, Your Honor.
No objection.
Or Mr. Breen?
That's right, Judge. I need to say something.
Mr. Fahey?
No, Your Honor.
All right, you may approach when you're ready.
Yeah, Your Honor.
You may.
Could you please introduce yourself to the court and spell your name?
Earl W. Briggs, Earl, E-A-R-L, W. Briggs, B-R-I-G-G-S.
Mr. Briggs, where do you work?
I work at the Cook County Medical Examiner's Office.
What job do you have at the Cook County Medical Examiner's Office?
I'm an investigator.
What are your duties as an investigator?
Our primary function is to assist the pathologist in determining cause and manner of death.
How does the medical examiner's office begin an investigation?
We get a phone call, usually from police departments, doctors, or nurses.
If that phone call reports a death and it falls within the medical examiner's office, what happens next?
We get the basically what happened. We create a first call sheet, which is computerized, and then once we've determined it falls under our jurisdiction, we create a case number, a case report.
What's the purpose of a case report?
Again, it assists the pathologist when he or she is trying to determine cause and manner of death.
What experience and training do you have in performing an investigation?
I was a police officer for over 31 years.
Where were you a police officer?
City of Berlin.
What jobs did you have as a police officer?
Patrol, juvenile, detective, tactical law officer, and I retired as a sergeant.
Do you have training in report writing?
Yes,
Do you have experience in report writing?
yes,
Were you also trained that making a false police report is a crime under Illinois law?
I'm aware of that.
How do you make sure that you have reported someone's statement accurately?
Well, basically, my policy is, after I listen to what happens, I kind of summarize what was told to me over the telephone. I basically ask, is there anything else I should know? Is there anything you want to add or delete to what you've told me? And if everything seems okay, then I'll generate a case number, case report.
And you'll confirm what you've read back is the statement that the person over the phone has provided?
Yeah, I try to confirm exactly what was told over the phone before I memorialize it and put it on a case report.
You take your job as an investigator at the medical examiner's office seriously.
Yes.
Let's talk about October 20th, 2014. Where were you working that night?
Investigations.
What shift were you working?
Midnights.
And is midnights 11 p.m. to 7 a.m. at that time?
Yes.
Did you take an investigation for the death of Laquan McDonald?
Yes.
Tell us what happened.
I received a call from a detective from Area Central.
Did the detective from Area Central identify themselves?
He did.
What did he identify his name as?
Detective March.
Did you identify yourself?
When I answered the phone.
In addition to Detective March, what other identifying information did you provide?
His star and his beat.
After Detective March gave you his identifying information, including his name, his star, and his beat, what happened next?
He basically, I asked him specific questions as far as the name of the decedent, address, date of birth, and then I try to get a quick summary of actually what transpired.
Did you confirm that summary with Detective March?
Yes.
Did you confirm that statement with Detective March?
What statement?
The statement that Detective March gave to you on October 20th, 2014.
Yes, before we ended our conversation, I again asked him if there was anything he wanted to add or delete or anything else I should know before I generated a case report.
And did he respond?
He did.
What did he say?
He says everything is affirmative, I guess.
Affirmed what you had read back.
Correct.
What reports did you make with this information from Detective March?
Medical examiner's case report.
With the court's permission, may I show to the witness People's Exhibit ME Report 1, which is tab 1 of the binder.
Is that in this big binder that you provided to the court?
May I, Your Honor?
Yes.
It's in the back here under Briggs. Briggs.
It's the second one.
That's what I'm looking. I see Snelling, Maris.
Right before Snell.
Right before Snelling. There it is. Thank you. ME Report 1?
Yes, Your Honor.
All right.
We would have an objection to falsification.
Okay, at this point, he's just asked him if he would look at it.
Okay,
So your objection is a bit premature.
very good.
Mr. Briggs, I'm showing you ME Report 1. What is that?
It's a medical examiner's case report.
For a death?
Yes.
Whose death?
Laquan McDonald.
On the last page of ME Report 1, whose signature is on the left-hand side?
Mine.
What date and time did you complete the report?
21st at 1:30 a.m. 21st of October, 2014.
Could you turn to page 3 and let us know when you're there?
I'm on page 3.
Under narrative, who furnished you the information for this report of the death of Laquan McDonald?
This was related to me by the Detective March.
Should you have an objection?
Yes, sir.
The way the questions are being asked, you're asking the witness to read a document that the witness created himself. Counsel, the proper way would be to ask the witness questions and document the witness's prior statement in a written document does not come into evidence. So I object. It's hearsay.
Mr. Watson?
This is an official public report that it was generated at the medical examiner's office. It is kept in the medical examiner's office, which we have stipulated to as an official report and public record of the medical examiner's office.
The protocol would fall under that by statute. So an investigator reports to counsel.
Mr. Watson? Anything further?
Not at this time. I can ask the witness a question
Okay.
at this point.
So you wanted to ask a question before I rule?
Your Honor, the objection is as to hearsay.
Right.
We are offering this for the falsity of the matter, not the truth of the matter. And the falsity of the matter is a statement reported by Detective March to Investigator Earl Brigs. And the false statement inside of this report, offered for its falsity and not for the truth of the matter asserted, is that the subject lunged at the officers. Hearsay is not a basis to exclude false information.
Anything
Would you like
for,
me to respond to that?
you can.
The declarant is on the witness stand. There's a way to ask a witness whether or not somebody told them something on a prior date, and it's not by having them read a report into the records. So it's a form of the question, and it is hearsay as to this declarant, unless the state's of the position that this witness's prior out-of-court statement is false, and if they do, we can stipulate to that. But quite frankly, the declarant is on the witness stand, and they're asking a declarant to read their prior statements into the record. Form of the question, it's inappropriate, and it's objectionable.
I join your objection, but we would also.
Okay. I don't recall Mr. Watson asking him to read anything.
I do, he's turning him to pages. And
He did. He turned him
asking
to.
to read what was contained in his report, as opposed to, if the witness needs to refresh his recollection with his report at some point, that there would be a proper foundation to be laid by that, but not to have the witness read his report into the record.
Now, I understand what you're saying. I don't recall him asking him to read out loud anything. So at this point,
Maybe I was anticipating.
I could be wrong. I'm going to let him go ahead and ask a question. For now, your objection is overruled. If you need to refresh or remake your objection, you can do that. Or if they ask a question that's based upon the objection that you just made, I'll rule at that time. Mr. Watson.
During your phone call on October 20th, 2014, with Detective March, did Detective March state to you the subject lunged at the officers with the knife?
I'm going to overrule it at this time.
Thank you, Your Honor.
Yes.
Where did you report or record the information that Defendant March stated to you that the subject lunged at the officers with the knife?
Objection.
Overrule.
At the medical examiner's investigation office.
And did you create a case report at the medical examiner's office with the information from Detective March that the subject lunged at officers with the knife?
Yes.
ME Report 1 is where you recorded that information in an official case report at the medical examiner's office, right?
Correct.
during your conversation with Detective March on October 20th, 2014, did you read back the information that Detective March provided you?
Yes.
Did you read back to Detective March the information including the subject lunged at the officers with the knife?
Yes.
After you had read back the information, including the statement that the subject lunged at the officers with the knife, did you confirm that information with Detective March?
Yes.
Did he respond?
Yes.
Did he respond affirming the information he had provided?
He did.
Your Honor, we offer ME Report 1 in evidence as a statement and act in furtherance of the conspiracy with a false statement recorded in the ME case report, and we do not offer it for a hearsay purpose. We offer it for its falsity.
Any objection, Mr. McKay?
Just the objections I've already made, Your Honor.
Mr. Pugh or Mr. Breen?
My objections would be that police report doesn't contain evidence.
Mr. Fahey?
Judge, we would have checked. It's hearsay and it's not relevant to Mr. Gaffney.
I'm going to withhold my ruling on this document coming into evidence at this time.
On one of the grounds that were objected to, Your Honor?
Yes, sir. Do you have any further questions of the witness?
I do have further questions. May I inquire which ground the court is reserving at this time?
I thought you were done with your direct, so I'll go ahead and just rule now. And you're asking that the entire report be admitted?
I am, Your Honor.
Can I ask a couple preliminary questions? Do the parties have any objection if I ask a couple preliminary questions?
Certainly not. No, Your Honor.
Okay. Is this report what is typically attached to a protocol, at the back of a protocol, or is it a report that's independent from that?
It is included in the case history of the report of post-mortem examination.
So it's a report that's typically attached to a post-mortem examination?
Yes.
Or a protocol?
Yes.
Okay. Does any... The objections of the defense attorneys is noted but overruled. It'll be admitted. Identification mark stricken.
Thank you, Your Honor.
You can proceed.
With the court's permission, may I show People's Exhibit ME Report 2 to the witness?
Yes.
Mr. Briggs, on tab 2 of your binder, I'm showing you ME Report 2. What is that?
It's a report of the post-mortem examination.
Turning to page 20, the last page, who signed the report of post-mortem examination for LaQuan McDonald?
Dr. Means.
Who is Dr. Means?
She was a pathologist that worked at the medical examiner's office back in October 2014.
What is the report of post-mortem examination for LaQuan McDonald dated?
January 15th of 2015.
And you recognize this report?
Yes.
Could you read for us the opinion and manner of death?
That he died of result of multiple gunshot wounds, and the manner was homicide.
In under opinion, it says, based on the case history and autopsy findings, it is my opinion that Laquan McDonald, a 17-year-old black male, died as the result of multiple gunshot wounds. Is that right?
Correct.
Manner of death is listed homicide. Is that right?
Correct.
Was the case report part of the case history for the death of Laquan McDonald?
Yes.
Was the information that Detective March furnished to you in that case report part of the case history for the death of Laquan McDonald?
It was.
Including on page 3 that the subject lunged at the officers with the knife. Is that right?
Correct.
Has Defendant March ever contacted you to correct that information?
No.
Where would you report if Defendant March had contacted you to correct that information?
I would have to report it to my supervisor.
The state offers People's Exhibit ME2 in evidence.
Any objection, Mr. McKay?
And by stipulation.
I'm not going to repeat my previous objections, but just stand by those.
Okay, Mr. Pugh or Mr. Breen?
Just point justice relevance as to Mr. Walsh.
Okay, Mr. Fahey.
The objection is to relevance as to Mr. Gaffney.
Okay, all of your objections are noted but overruled. The identification marks are stricken. It's admitted.
Nothing further at this time, Your Honor.
Okay, Mr. McKay, cross.
Mr. Briggs, did you ever meet Detective March before this night?
Not after that.
You never met Detective March that night.
Correct.
Did you ever meet a Detective March before that night?
Not that I recall, but I have had dealings with area central detectives, and we may have crossed paths before. I don't recall him personally.
And do you recall ever talking to a Detective March before that night?
No.
So you can't say with any certainty that the person who called you was indeed Detective David March, can you?
You're correct.
To be clear, the voice you heard on the other line of the telephone, you had never heard that voice before, correct?
Correct.
Perhaps if you did, then maybe you'd recognize who it was, right?
Yes.
But that didn't happen in this case. Did it?
No.
You have the exhibit in front of you, Mr. Briggs?
Which exhibit? I have two in front of me.
The case report.
Yes, I do.
All right. Now let's be clear. You prepared that case report, right?
I did.
No one else prepared that report besides you.
Correct.
And your shift started about 11 p.m. on the night of October 20th, 2014?
Correct.
And your shift would have ended what time the following morning?
7 a.m.
7 a.m. And you started working at the medical examiner's office 2012, right?
Correct.
This is your second job, correct?
Correct.
Because you were a policeman in Berwyn for, what, 31 years?
Correct.
Is becoming an investigator at the medical examiner's office, at least at the time you get hired, was that kind of like a political job?
I don't know.
Did you need any help to get the job at the medical examiner's office in 20?
No.
Okay. Now, working the midnight shift back in October 2014, you didn't always go out on any shooting, did you?
We had a protocol on what we went out on.
And to be clear, in this case, you did not go out on this shooting incident, right?
Correct.
You just stayed in the office.
I did.
Took phone calls.
Took this phone call.
Okay. And by the way, do you recall how many other investigators were working the night of October 20th, 2014, besides you?
I have no idea.
And if you were short-staffed, or you and others are away from the phone calls coming in would not be answered, correct?
Well, there's always somebody in the office.
But if somebody is not at the phones, maybe having coffee, it's possible a call can come in and not be answered, right?
There's always somebody in the office.
Are you saying that calls coming in will always be answered?
All I'm saying is that there is always somebody in the office.
And if that somebody is in the office but not at his desk where the phone is, maybe having coffee, that call isn't going to be answered at that time, right?
I can only say that there's always somebody in the office.
Mr. Briggs, this call, whoever it was made, strike that. This call, whoever truly made it, was not audio recorded, was it?
No.
And this call, whoever truly made it, you were not taking notes at that time. Isn't that correct?
Correct.
And the report, the case report you have in front of you, that is your final report, isn't it?
It's my final report, yes.
I see. And in this case, your first draft was your final report, isn't that right?
Yes.
Thank you. So what you're telling this court is this report that you have in front of you, there were no changes. This final draft, sorry, this first draft was your final report that you signed, right?
Yes.
And what time did you submit this report, Mr. Briggs?
We hit officer complete, and whatever the completed time is on the report. It was...
Well, Mr. Briggs, I didn't ask you that. I asked you, what time did you submit the report?
It's all computerized. Once I sign off on it, the computer generates the date and time.
Okay. So what is the date and the time that this report that you did was completed?
Do you mind if I...
Of course, please.
It was completed by me on October 21st at 1:30 a.m.
And what time were you assigned this case?
Again, can I...
Please.
The detective notified me at 11:51 on the 20th of October.
So is that the date you were assigned?
Yes, that's the time I took the initial call in.
Is that the time you were assigned?
Yes, if we take it in, we're pretty much assigned the case.
So if somebody wrote down that you were assigned this at 12:32 in the morning, not at 11:51, that would be a mistake, correct?
I'm not sure exactly what you mean by a mistake. I mean, I initially get the call, the computer, once I get the initial call, the computer will generate the date and time.
Oh.
Okay? And then it can be assigned. Now, sometimes, me personally, I will start doing the report before I even hit the box assigned. But, I mean, as far as being assigned, when we initially get the notification is when we're basically getting assigned. We have time of notification, an investigator, time assigned. If I'm doing the case from the beginning, I may not hit the box assigned, because I'm already assigned it when I took the first call in.
May I approach?
You may.
Mr. Briggs, you just told us you were assigned this case at the time of the call, 11:51 p.m., right?
That's when I took the first call.
Thank you, sir. I want to show you an exhibit we'll mark as defendant Mark's exhibit number 4 for identification. What is this, Mr. Briggs?
This is my first call.
And look at the section here at the top on the right-hand side, date and time assigned. What does it say?
11/21. I'm sorry, 10/21.
That's the date.
Correct.
What's the year?
2014,
What's the time?
12:32 a.m.
Not 11:51 p.m. Correct?
Correct.
Well, which is it? Were you assigned at 11:51 p.m. on the 20th or 12:32 a.m. on the 21st?
Again, I took the call in. Once I start taking in the call, the computer will generate the time that we've been notified. That's the notification time of 11:51. There's a separate box for when assigned. That's just a drop-down box. I've already been assigned the case when I took it in.
And you took
The drop-down box, I didn't put that I was assigned it because I've already been assigned it technically when the first call came in.
Well, who put in 12:32 a.m. on exhibit number 4?
Well, I must have.
You did?
I must have.
So you chose to put 12:32 on that one form, but you say you actually got the case at 11:51 p.m.
The call came in at 11:51.
And we get, regardless of what the time was when you got assigned or when the call came in, you're telling this court that everything in that case report you prepared, that information is from Detective March. Is that correct?
Was related to me by him.
Everything. Correct?
As far as the narrative, yeah, correct. Yeah, everything. Everything that I could see here, yes.
And you're telling us that you finished your report then at 1:30 in the morning.
I, again, hit the drop-down box, completed by, and that was the time that the computer generated it.
And this is the only report you prepared in this case.
Yes.
Yeah, approach.
You may.
Mr. Briggs, I'm going to show you the exhibit that I have marked as March exhibit number 3 for identification. You recognize this, sir?
Yes, sir.
This is a copy of your case report that you prepared in this case, right?
It appears to be yes.
It's 4 pages, isn't it?
It is.
Just like the state's exhibit, NE Report 1, right?
Not exactly, but yes.
So, and this exhibit, the defense exhibit number 4, appears to be in the same or substantially the same condition today as it was when you completed it by 1:30 a.m. on October 21st, 2014, right?
It appears to be.
Thank you, sir. Now, I want you to take a look at those 2 reports side by side, okay? You see both of those reports?
I have them next to each other, yes.
Now, the state's exhibit, that's not signed by your supervisor, is it?
No.
The exhibit I just gave you, defendant's exhibit number 3, that is signed by a supervisor.
Correct.
All right, so there's one change. Would you agree?
Yes.
All right, now let's go back and forth now. Now, regarding the report that the state submitted to you, the first page under the section decedent/subject, you see that?
Yes.
Are you telling this court that David March told you that the decedent had a home address of 501 North Springfield, Chicago, Illinois, 60624?
Yes.
Okay. So you're telling this court that David March, if that's who it was, gave you the zip code of the decedent's address?
Yes.
All right. Now take a look at the report that I gave you. In that report, it includes the decedent's address, but it also includes county, Cook County. See that?
Yes.
So that's another change, different from the state's exhibit. Would that be fair to say?
Yes, it is.
Okay. Now, further down on page 1, under the section discovered, it says discovered by Chicago beat 845 Robert. You see that?
Yes.
And the address, 3420 West 63rd Street. Do you know what that address is?
I believe it's the 8th District.
Okay. And I believe you're correct. But are you telling this court that David March, or whoever identified himself as David March, gave you the address of the 8th District?
No, he did not. I know for a fact he did not.
He didn't?
No.
Okay. So, contrary to what you said a few minutes ago, not everything in this report came from David March, right?
Correct.
Take a look at page 2, please.
Of which one?
Both reports. On the state's exhibit, Mr. Briggs, it says, under place of occurrence, the address where the incident occurred, it says 4112 South Pulaski, Chicago, Illinois, right?
Correct.
And there's a zip code of 60632 there, right?
Correct.
Are you telling this court that David March gave the zip code of where this incident happened?
I believe he did.
When you say you believe it, are you saying that maybe you're not sure if he did or not?
It says 60632. I wouldn't have come up with that number on my own.
Well, if that's true, you would have come up with the zip code. It's also true that you on your own came up with the address of the 8th District, though, right?
Yes.
I'll ask you again. Did David March give you the zip code of the incident where it happened?
I believe he did, yes.
But you're not sure. Is that right?
I believe he did.
Okay. Look at the next section on page 2 where it says identification of deceased. You see that section?
Yes.
Okay. Let's take a look at the state's exhibit. It says police identification, police. Identification means photo ID. You see that?
Correct.
Did that come from David March?
Yes.
All right. Now take a look at the other report, Defense Exhibit 3. There it says positive identification, coworker. And identification means fingerprints, right?
Correct.
So one report says ID by police, photo ID. Other one says ID by coworker and fingerprints.
Correct.
Which of those two?
Mine.
So David March didn't give you either of those.
No, he gave me how he was ID'd, obviously.
He did?
Well, he gave me an IR number.
Okay. Well, who decided to change the ID from police to coworker and the means from photo ID to fingerprints? Who decided to make that change?
I have no idea.
What you're telling this court, strike it. Both of those different answers did not come from David March. Are you?
On my report, where it says ID'd by photo ID, he gave me an IR number. He based his ID at that time based on Chicago IR number. I stand by my report.
Well, both of those exhibits are your report, Mr. Briggs. And on the report, Defendant's Exhibit 3, which your supervisor signed, it says coworker and fingerprints for the identification process, doesn't it?
Yes.
So which is it? Did Dave March tell you he was ID'd by a photo ID, or did he tell you he was ID'd by fingerprints? Or did he tell you none of those things?
He told me he was ID'd by his IR number. I stand by my report.
But both reports are different, Mr. Briggs. How do you explain that?
The only thing I can say is that this report has been changed. My signature will stay on it, even if it's been edited for clerical reasons, for punctuality. My report will stay on. I am standing by my report that is not signed by the supervisor. That is my report.
A second ago, you told us everything this report came from Dave March. Are you now telling us that this report was, strike it, are you now telling us that one of these reports was edited?
Well, obviously it was.
By whom?
I have no idea, sir.
So if a caller comes in and says something to you, whatever that information is could be edited by somebody in your office? Is that what you're telling this court?
Yes.
Well, you got to admit to this, Mr. Briggs, right? Your report then, strike it, in general, your reports aren't that accurate. Would you agree with that statement?
My report is accurate.
Even though
the report that I turned in.
Only one can talk at a time, please. Mr. McKay, let him answer the question.
Yes, sir. Go ahead.
The report that I turned in without anybody else's signature is my report, unedited. No changes for punctuality or for whatever other reasons.
Well, but this isn't about punctuality, Mr. Briggs. This is substance. One report, not approved by your supervisor, says police and photo ID for the identification of the deceased. And the other report says coworker and fingerprints for the identification of the deceased. That's not punctuation. That's substance. Would you agree with that, Mr. Briggs?
I do.
You can't tell us who made that substantive change, or can you?
No.
All right. Dr. Strike that. Look to the next section, pronouncement. You see that on page 2?
Yes.
Place deceased pronounced. It says hospital ER, right?
Correct.
And pronounced by, you wrote, did you not, Dr. Titeel, T-I-T-E-E-L.
Correct.
That's what you wrote. Did you verify this information and learn that that doctor's name wasn't Titeel, but instead it was Pitzele, P-I-T-Z-E-L-E?
Did I confirm it with who?
Did you, with anybody?
Nobody.
So if you misspell a doctor's name, that's not corrected, right?
Well, it depends if they know it's a mistake. It would be corrected.
Did you know it was a mistake?
No.
Because you didn't verify any of this information, did you?
No.
In fact, and I mean no disrespect, while you are an investigator, you didn't investigate anything in this case, did you?
I took the initial, that was it.
Look at page 3, please.
Of the same one? Case report?
Both reports. Now, on your report, strike that, on the state's exhibit, where it says next of kin notified, there's a box, isn't there?
Correct.
And on the state's exhibit, that box is not checked, correct?
Correct.
And on the defendant's exhibit that you're looking at, which was approved by your supervisor, that box is checked, right?
Correct.
Can you explain to us why one report has a box checked and the other report does not?
I can't explain that.
But you still will maintain you're the one that drafted this report, didn't you?
I stand by my reports. The one that's on it that does not have a supervisor's signature on it is the report I submitted.
Will you maintain that you're the only person that drafted this report?
To the best of my knowledge, but obviously there's been changes.
All right, let's take a look at the scenario, okay? On page 3 of the report, Mr. Briggs, focusing your attention to the very first paragraph of the state's exhibit, it indicates that the Chicago Police Department Area Central Detectives Beat number was what?
5121.
But on your unapproved report, it says 5121R, correct?
Correct.
Are you telling us, sir, that Detective March told you his beat was 5121R?
The R may have been me putting that in, well, because we deal with mostly R cars on midnights, I may have inadvertently put R in there. I am not sure if R was his beat, but 5121 I will stand by.
So the R could be a mistake made by you in this report?
Yes.
Because that R was taken out of the report I've marked as Defendant's Exhibit 3, right?
Correct.
Who did that?
I have no idea.
Mm-hmm. All right, next paragraph, Mr. Briggs. It's stated, and correct me if I'm wrong, I'll read this verbatim. Detective March related the following, semicolon. On or about 21:56 hours, 19 October 2014, Chicago Police. Did I read that first line correctly?
You are correct, and I put the wrong date in.
That's a mistake.
Mistake by me.
Fair enough. But my question to you is, forget about the 19 instead of the 20. Are you telling this court that Detective March, or whoever claimed he was Detective March, said on or about?
No, that's my words.
But it's in the narrative section, Mr. Briggs. You just told us the narrative came from Detective March.
Okay, yes.
So you told, so to be clear, whoever called in that night told you on or about. Is that what you're telling this court?
No, I put that in all my reports.
So then this narrative section is not completely from this person who identified themselves as David March, right?
Based on that question, yes.
Three lines down, and correct me if I misread this. Upon arrival of beat 815 Robert was confronted by the subject who threatened the officers with a 4-inch fold knife. Did I read that sentence correctly?
Yes.
Are you telling this court that that Detective March told you it was a 4-inch knife?
Yes.
Now, there are times, are there not, Mr. Briggs, that sometimes you put words in quotations in the narrative section, right?
Yes.
Meaning that when something's in quotations, it's the exact words used by the caller. True?
True.
So, a couple lines down, the sentence begins, you see this, sir? The officers announced their office as, quote, Chicago police officers, close quote. Did I read that correctly?
You did.
All right. So what you're telling this court is, did this person who identified himself as Detective March say that the officers warned the offender that they were Chicago police officers?
They announced their office as Chicago police officers. Yes.
And the following part of that sentence says, and ordered the subject to drop the knife. Did I read that correctly?
You did.
Now, the next sentence, Mr. Watson asked you about. You wrote, the subject lunged at the officers with the knife. Did you write that?
I did.
And are you telling us that this person who claimed to be Detective March used the word lunged?
Yes.
You did not put the word lunged in quotation marks, did you?
No.
The next paragraph. It talks about Chicago Fire Department ambulance number 21 transporting the deceased to Mount Sinai Hospital, right?
I don't think it says that they transported the deceased to the hospital. They just transported the subject to the hospital.
Okay. Well, the subject we're talking about became deceased.
He did become deceased, but he wasn't deceased when we were taking him to the hospital.
True. In fact, he wasn't pronounced deceased until he got to the hospital, right?
Yes.
Even though you never called the doctor who pronounced his death, did you?
No.
But nevertheless, you wrote 3 lines down. It appears the subject sustained the following gunshot wounds: 4 to the chest, 6 to the right arm, 5 to the left arm, 1 to the right torso, 2 to the back, 1 to the right hip, 2 to the left leg front, 2 to the left leg rear, 2 to the left thigh, and 3 to the right. Did I read that correctly?
You did.
Now, are you telling this court that this person who identified himself as Detective March gave you all of that information I just read?
He did.
Can you explain, Mr. Briggs, that if Detective March, the real Detective March, was still at the scene at 11:51 p.m., how in God's name would he know all of that information?
Based on your question, I have no idea.
Thank you. Let me ask you this. During your night at the NNE's office, did you know if there were other people at Mount Sinai Hospital calling in, relaying in any information about the subject?
Not to me, no. I have no knowledge of that.
Would somebody like Mr. King, your supervisor, or anybody else working that midnight shift, could they have received calls from somebody that was at the hospital?
They could have, but if they did, usually what they'll say is, hey, you know, I got an officer on the phone in reference to your case. That night, that did not happen.
You certain about that?
Am I certain about what?
That did not happen. Some coworker took a phone call from somebody at the hospital.
I have no idea what other coworkers did, sir.
By the way, do you have the phone records from the medical examiner's office from the night of October 20th, 2014 into the early morning hours of October 21st?
I don't know if any exist. I don't have any.
So there's no way to corroborate from medical examiner phone records whether there were other phone calls from other locations about this subject, correct?
I can't answer your question because I don't know. I don't know if there's phone records.
Mr. Briggs, I'd like to direct your attention to 2 paragraphs down in that narrative section. It's just 1 sentence, and it reads, the subject was ordered, along with all police reports, medical records, which included admission blood, which was drawn to the Forensic Institute for further examination. Did I read that correctly?
You did.
And that's in the narrative section, isn't it?
It is.
Are you telling this court that you ordered this person who claimed to be Detective March to bring to you blood samples drawn from this subject at the hospital?
According to my report, I did.
You're kidding. Well, sorry, Ted. So, the medical examiner of Cook County, Dr. Cena at the time, and his staff, the policy was for police officers to bring blood samples from a hospital to the morgue. Is that what you're telling us?
No, that's not what I said.
But you're writing that you ordered this person named March to bring a blood sample of the subject to you.
What my report says is that I ordered police reports to our office along with medical records and admission blood.
And you
Who sends it? You know, usually the medical records, and if there's admission blood, come with the remains.
Okay. Well, let's talk about the police
It's a
report.
procedural question that we end with. I need all police reports, medical records in reference to this incident, and admission blood. That's how we end our conversation with whoever we're talking to.
And in this case, did somebody deliver to the medical examiner's office the police reports in this case?
I don't know. I assume they did.
Well, you're assuming.
I don't follow up on that, sir.
You didn't do any follow-up in this case, did you?
No.
So you don't know, or do you, that all the police reports done by a detective, David March, all of them do not include the word lunge. Do you know that or not?
I don't. I don't know I haven't seen any reports from him. I haven't seen any Chicago police reports.
Did you ask for any police reports from the special prosecutors?
No.
Okay. And how many times have you met with the special prosecutors before tonight?
Or which one?
Take your pick.
The young lady, I met her once, and then the gentleman just to her right, I believe 2 or 3 times.
There's a lot of young ladies.
Oh,
Miss Holmes?
yes.
And how many times did you meet with Miss Holmes?
Just once,
Yeah. When? How long ago?
about 2 weeks ago.
Okay. What about the others on our team?
The gentleman just to her right, I think I met him 3 separate times.
You did?
I believe so.
Where?
2 or 3. Our office. They came down to our office.
So you met with the special prosecutors at least 4 times, right?
No, I don't think it's been that many. 2 or 3, and then the last time they came together.
All right. So about 2 or 3 times.
2 or 3 times.
I called you a couple weeks ago, didn't I?
You did.
I asked if I could meet with you, right?
You did.
You didn't want to meet with me.
That's not how we originally set up an appointment.
Then what happened?
I was told to call you back.
By whom?
My boss, my
What's
chief,
his name?
Christopher Kalka.
Is he here?
I don't see him.
What did Mr. Kalka tell you?
He said that with the notice that you gave me, which was about 2 or 3 days, because I think we originally set it up for a Monday. I think he called me on a Thursday. He said that the county has representation for me, and there was not enough time for the attorney to meet with the 3 of us.
This is Mr. Kalka telling you this.
You are correct.
Your boss.
Yes.
Hired by the recent administration, right?
Yes.
Wasn't your boss in 2012.
No.
And he's not a lawyer.
I don't believe he is.
Right. And because your boss told you you needed representation, you chose not to meet with him.
No, what he said was the county has given me representation, and there was not enough time for the attorney, the 3 of us, to meet with the short notice for me to cancel the appointment.
Did you need representation?
I didn't think so.
By the way, had you met with me, you know we would have gone over these 2 reports. You know that, right?
Well, I sure hope so.
Yeah. I mean, all of this could have been avoided, Mr. Briggs. You get that, right?
Oh, I got it.
Thank you, sir. Could you please turn to page 4, Mr. Briggs, on both reports? See where it says the section C near the top? As a point of contact under this section is Detective March with the star number, right?
Yeah, point of contact.
Yeah, okay. And right underneath it, it says temperature of environment. It says 52 degrees Fahrenheit.
Correct.
I read that correctly, right?
You did.
Thank you. And by the way, are you telling this court that this person who claimed to be Detective March told you it was 52 degrees Fahrenheit out there that night?
No, he did not tell me that.
You just put that in there.
Well, I didn't put it in there. I checked what the temperature was.
So all of this report did not come from Detective March, correct?
Correct. The narrative part of my report was from Detective March.
What does it mean in the middle of page 4? Photographs taken on scene false. You see that part, Mr. Briggs?
Yes.
What does that mean?
I have no idea.
And this is your report.
Right, but again, that's computer generated. That is not a drop-down box by us.
Now, at work, like that, at work back in October 2014, you had a computer, right?
I did.
You had a cell phone, right?
I did.
You had or in the office where the investigators are, you had a radio. Right?
A radio?
Yes, sir.
There's one in the office, but we don't use it.
Well, I didn't ask you that. Do you have a radio there or not?
Well, there's 3 radios in the office.
Is there television anywhere around? If not in the investigator room or break room or anything like that?
I don't know.
Mm-hmm. And you've been
in our office, no.
And you've been working there for 6 years?
Correct. I don't go to the break room.
This phone call that came in, do you know how long that phone call lasted?
I have no idea.
During this phone call, if you were the only one there, is it possible you put that caller on hold to temporarily take another call?
If I was the only one there.
That would be possible.
To answer your question, the answer is yes.
Okay. And do you know, sorry, at the time, did you see any of the news events regarding this case?
Which day?
Well, that night into the next morning.
No.
Well, you heard of an FOP spokesman named Pat Camden, haven't you?
I've heard of him.
Yeah. And did you see, it's right there, you know about the press conference Pat Camden had from the scene that night, don't you?
No.
You don't?
No.
So you have no knowledge that a Pat Camden, not somebody named March, claimed the offender lunged at the officer, or do you?
I don't. I have no knowledge of that conversation or Pat Camden being on the scene.
Whatever you wrote in the narrative, right there, whatever the caller may be telling you regarding what happened, whether the person lunged or not, has nothing to do with manner and cause of death, right?
Correct.
When a person calls in, do you put them on a speaker, or do you just listen up to your ear with the phone?
I listen up to the ear.
All right. And you got to hold that with one hand, I presume, correct? Or do you nudge it on the shoulder?
Sometimes one or the other.
Do you recall which did in this case?
No.
Well,
I'm usually a holder.
Thank you for sharing.
Thank you for asking.
I'm here to help.
Thank you.
Mr. Briggs, you see defendant's exhibit 4 here. May I approach you?
Yes.
Could you please tell us, Mr. Briggs, what is defendant's exhibit number 4?
Basically what this is it's the computer printout that once I've created the report, I actually created it, and that's what this is. It's my basic first call, and then it's my narrative.
So
it's not this. This is at the bottom of this. It'll say create report, and then we will get that. This is my narrative in here.
Is defendant's exhibit number 4 different than in the case of?
Yeah, paperwork is different. Yes.
So this is another report you did. Is that right?
This is the first call. This is what's in my computer.
Let's talk about that first call.
Okay.
Are you telling this court that the first call came from Detective March?
I'm saying I took a phone call from somebody who identified himself as Detective Marsh. Correct.
And is the narrative in the first call section of Defendant's Exhibit Number 4 information you received from this person who named himself Detective March?
It looks like it, yes.
It's only 2 lines, isn't that correct?
No, actually, it's 3 paragraphs.
But the first call is only a couple lines. Right.
Correct.
And correct me if I'm wrong, that first narrative, first call narrative, reads as follows. Chicago police responded to a call of a subject being held by a citizen. Upon arrival, subject threatened officers with a knife and fled. At 4112 Pulaski, subject was confronted by B845R and threatened officers. Officers fired service weapons striking subject 16 times, right?
Correct.
That is the total of the first call narrative, correct?
Correct.
Nowhere in that first call narrative is the word lunged used or mentioned, correct?
Correct.
Or typed by you, right?
Correct.
And that section, that first call narrative section, that ends. And then there's another section that's labeled narrative, right?
Correct.
I'm just a little confused. Was there one call or was there more than one call regarding this case that night?
Taken by me, 1.
Could there have been a second call taken by somebody else at your office?
I don't believe so, no.
When you say I don't believe so, are you saying no, or it's possible you just don't know about it now?
I'm saying no.
So you don't believe so, or you're certain there wasn't a second call?
I am certain there wasn't a second call.
Just got a moment.
Take your time.
You have Defendant's Exhibit 4 there?
Which one is 4?
The first call narrative.
No, I think you have it.
I'm sorry. I just want to be clear, Mr. Briggs. Taking a look at Defendant's Exhibit Number 4, where it says FC narrative. That means first call narrative, correct?
Correct.
Did the information in that section, FC narrative, did that information come from Detective March?
Yes.
Thank you. And to be clear, there's no audio recording of this conversation with this person. True?
True.
And I asked you this, but I'm not clear. Did you take notes during this conversation, or did you not?
No, everything is basically, I'm typing as I'm asking questions.
Now, Mr. Briggs, do you remember meeting with Mr. Watson and his investigator on August 25th of last year, 2017?
I met with him. I don't know the exact date or when.
And you met with him at the medical examiner's office, right?
I think all our meetings were there, yes.
Okay, with your boss, Christopher Kelko.
Yes, there was one that he sat in on.
Yeah, and during this interview with you, was their investigator, a gentleman named Vincent Williams, was he taking down notes?
I don't know. I don't recall if he was. I don't know. I don't know who he came with, so I don't know. You're telling me he's an investigator? Okay, he's an investigator. I don't know. I don't know who he came with.
Did the person who came with Mr. Watson identify himself?
Oh, he may have, but I mean, we're talking a year and a half ago.
More recent than the incident of October 20th, 2014, right?
Yes.
So, this person who came with Mr. Watson to your office last August of 2017,
They asked you some questions, didn't they?
They did.
But, true or false, they didn't ask you specific questions about this caller using the word lunch. Isn't that correct?
I don't understand the question.
Well, during the interview, did Mr. Watson or his investigator, Vincent Williams, did they specifically ask you questions about this caller who identified himself as Detective March using the word lunch?
I don't recall their questions.
It was Mr. Watson taking any notes or going on a laptop computer. This gentleman right here.
I don't recall.
Don't remember, or just, I'm sorry, could it have happened, you don't remember, or did it not happen?
Oh, it could have happened. He could have been taking notes. I don't recall.
Okay. Mr. Briggs, thank you very much. Your Honor, I have no further questions.
Thank you. Mr. Pugh or Mr. Breen?
On behalf of Mr. Welch, Judge, no further questions.
No questions on behalf of House.
Okay, any redirect, Mr. Watson?
Can I retrieve my exhibit, sir?
Yes.
I don't think you're up here, Counsel. This was nice. Yeah. Okay. Thank you, sir.
Your Honor, can I just open up my direct for just a second?
You want to reopen your cross?
Yeah, my cross.
Yes, you may.
Thank you. Mr. Briggs, Exhibit 3, Defendant Exhibit 3 and Defendant Exhibit 4.
Okay.
Are these exhibits true and accurate copies of the reports you prepared in this case?
Again, we question the one that's signed by the supervisor. I am sticking to my report that's not signed by the supervisor.
But for the supervisor's signature,
correct,
is everything else in Exhibit number 3 and Exhibit number 4 true and correct to the best of your knowledge?
I am standing by my report, not that report.
So you're saying this is not a true, accurate report?
It's not. This is the report I made out. Any changes in your document, I don't know who changed.
When he says this is the report, if you could clarify for the record, is that the one that he's referring to without the supervisor's signature, is that Defense 3?
No.
Is it Defense 4?
It's State 1.
State 1.
The signature, the approved report is Defense Exhibit 3.
Okay. Thank you.
But for the signature is everything else in this document your report?
No, they're different. The two reports are different.
Can you explain why?
I have no idea.
Exhibit 4. Is this a true and accurate copy of this computer drop-down report?
Yes, to the best of my knowledge, yes.
All right, this time I move to admit Exhibit 3 and 4.
Any objection? Let's do Defense 3 first. Any objection? State?
None as to Defense 3.
Any objection regarding Defense 4?
None as to Defense 4.
Okay, so Defense Exhibits 3 and 4, the identification marks are stricken, and they will both be admitted. All right, do you rest in your cross now? Okay, redirect.
Your Honor, may I approach?
You may.
Mr. Briggs, I'm showing you Defense Exhibit 3, the Medical Examiner Investigations Case Report, which includes the supervisor's signature. Do you see that?
I do.
Could you explain for us how a report with someone else's signature may have someone else's changes?
It's just all computer generated. He approves the report, reviews the report, and he signs off on the report.
So if the supervisor who signs the report also makes changes to the report, the supervisor's changes will appear in the report.
Correct.
On Defense Exhibit 3, the exhibit that Mr. McKay asked you a lot of questions about, It states the subject lunged at the officers with the knife. Is that right?
Correct.
Is there any doubt in your mind that Defendant March told you that on October 20th, 2014?
Objection to the formal question.
Overruled.
There's no doubt in my mind.
Is there any doubt in your mind that you read back the details of your narrative, including the statement that the subject lunged at the officers with the knife to Defendant March? Is there any doubt in your mind that you did that?
There is no doubt because, like I said before I ended the conversation with him, I asked him if there was anything else I should know. Is there anything that he wants to add or delete to what we've already discussed? And he said no. I hit the case, create case.
Defendant March affirmed for you the information he provided, including the subject lunged at the officers with the knife when you read it back to him on the phone.
Correct.
I'm showing you Defense Exhibit 4, which is the printout that Defense Counsel also showed you. Is that right?
Correct.
In Defense Exhibit 4, it states the subject lunged at the officers with the knife. Is that right?
Yes.
Is there any doubt in your mind that Defendant March provided the information that Defense Counsel asked you about on Defense Exhibit 4 that the subject lunged at officers with the knife?
There is no doubt in my mind.
And you read back that information, and Defendant March affirmed that information?
Correct.
There were a number of questions about this person who called you. That person identified themselves as Detective March?
Correct.
That person identified himself as Detective March with a star number?
Correct.
That person identified himself as Detective March with a star number 20563 as reflected on your report?
Whatever's reflected on my report.
The person identified himself as Detective March, star number 20563, and an area central detective, right?
Correct.
Have you seen Chicago Police Department reports that detail notifications made to the ME's office? Have you ever seen those?
I've seen Chicago Police reports, yes.
Inside of a case supplementary report or a case incident report, an officer or a detective will detail who they provided notification to, and that would include an ME's office notification sometimes.
Usually the report's done by a beat officer.
And it would identify, for example, if you were notified, E. Briggs or your investigator number. Is that right?
Chicago PD has a box that says ME notified.
You stand by what has been marked as People's Exhibit ME Report 1 that you signed.
The one that has just my signature, I stand by.
And the one that just has your signature, People's Exhibit ME Report 1, includes the statement that Defendant March gave you, and you recorded the subject lunged at the officers with the knife, right?
Correct.
You read back the details of that narrative to Defendant March?
I've been asked to answer.
Sustained.
And Mr. McKay asked you a number of questions about the investigation you did in this death of LaQuan McDonald, right?
Correct.
You wrote a report that relied on the information that the Chicago Police Department, through Defendant March, provided you.
Objection. The witness is testifying. He doesn't know who the person was who identified themselves as March.
That's sustained to the form of the question. Just rephrase.
So, you relied on the details of an investigation that the person who identified himself as Detective March from Area Central Detectives, star number 20563, provided you about the killing of LaQuan McDonald. Is that right?
Yes.
Since the killing of LaQuan McDonald, protocol has changed at the ME's office.
Objection. Now it's beyond the scope.
Mr. Watson?
This evidence and this answer goes to the change that has occurred as a result of the false information that was provided to the ME's office in this case from the death of LaQuan McDonald.
And how, Mr. McKay, let me rule. How is that relevant?
It goes to the veracity of Mr. Brigs' testimony. He has now changed what the ME's office does because of the false information that was provided in this case by Defendant March.
You're saying Mr. Briggs changed it?
Mr. Briggs and the investigators have changed their protocol at the ME's office.
Any further response, Mr. McKay?
This is beyond the scope and it is not relevant.
That objection is sustained.
When there's a police-involved shooting, do you now go out to the field?
Objection beyond scope.
That's a rule.
If the remains are still on the scene, we always went out.
Nothing further, Your Honor.
Okay. Any recross, Mr.
Very briefly, did
McKay?
I hear you correctly, Mr. Briggs? Did you just say that you have no doubt in your mind that you read back this narrative to this person who called himself Detective March?
Basically what I said when I ended the conversation was, is there anything else I should know to what you've already told me? Is there anything you want to add or delete? And the answer was everything he told me was correct, and I memorialized it on our case report.
But didn't you just say to Mr. Watson that you have no doubt in your mind that you read this back to this person who called himself March?
I didn't read the narrative back to him.
You testified before the Inspector General's office on July 20th, 2016. Isn't that correct?
I don't know the date, and I spoke with 2 or 3 different IG officers, so I'm not sure which one you're referring to.
And those 2 or 3 IG officers would include a Mr. Peter Newmer and a Mr. Christopher Brown. Does that sound about right?
I don't know. I don't know their names. Like I said, I spoke with County IG and I believe the City of Chicago IG.
And that was at 300 West Adams on the 8th floor.
Isn't that correct?
I went downtown for something. Was that with the IG? Okay.
And you didn't go downtown alone. You went with your boss, Mr. Kalka, right?
I went downtown with him on one occasion.
Yeah, but no lawyer, right? Mr. Kalka was with you that day.
He was with me that day.
And you were placed under oath on July 20th, 2016, weren't you?
Yes.
And these events were more fresh in your mind then than they are today, aren't they?
Yes, I'll go with that, yes.
And when you were placed under oath, you were telling the truth, weren't you?
Yes.
Page 38, line 4. Were you asked this question, did you give this answer, Mr. Briggs? Okay. Do you have a recollection whether you read back this narrative to Detective March on October 20th, 2014? Answer, I don't recall this specific, but it's my normal practice. When you ask that question, did you give that answer under oath on July 20th, 2016?
Yes.
Nothing further.
Anything further there, Mr. Watson?
Nothing further, Your Honor.
Thank you. You're excused. You may step down.
Thank you, Your Honor.
It's going to take just maybe a 5-minute recess. Okay, so all of the defendants, you could be seated if you want. You could stand if you want. It's very late. If you want to stretch, that's fine. And I've been told that first of all, the record should reflect that all of the defendants are present with all of their attorneys. All of the special prosecutors are present as well. I've been told that the next witness is very lengthy. It's almost 6 o'clock now, so we're going to call it a day for today. So this case is going to be order of court November 28th with per bench commenced and continued. I think we could start, I'm going to try to start around 11. Does that work for everybody? Around 11? Mr. McKay?
Yes, yes.
And Mr. Pugh or Mr. Breen?
Fine.
Mr. Fahey?
Yes.
All right, everybody have a good night, and I'll see you tomorrow. Oh, I'm sorry, there is one matter. There is one matter. So there's a motion to exclude witnesses, and I did not rule on the motion to quash the subpoena. I've been informed that Mr. Topic, is he still here? Is he here? No? Okay, is anybody here that has contact with Mr. Topic? I guess that's a no. All right, then I'm going to direct the court reporter.
Well, I can get a cell phone. He emailed me.
Nope, I'm going to direct the court reporter. He's requested a transcript, and I need to give him admonishments before that transcript is released to not disclose that transcript to the witness because there's a motion to exclude witnesses. So if he's here tomorrow, I'll address that tomorrow. But Ms. Court Reporter, do not tender that transcript until I give the admonishment. And with that, everybody have a good night, and I'll see you tomorrow.